encourage and support tech entrepreneurship here in the province. So we've done that in a few ways. We have a online distance venture acceleration program, which is a kind of a one-to-one mentorship program for startups. We have an online market validation training program, which really any of you can do for free. It's free for anyone in BC. If you want to do some market validation on the business you're working on, go online and give it a try. And the ISI grant program is our job grant program funded by the province of BC and Innovate BC. And it is, if you want to hire a post-secondary student, you can get up to $10,000 a year of matching salary. And of course, the New Ventures BC competition, which is also presented by our title sponsor, Innovate BC. I know a lot of you attending are in this year's competition, and thank you so much for applying and competing this year. We're super, super excited to have so many people in this year's competition. We actually had a record number of applications this year, over 230, and over 200 of you are going to be submitting to round 2. So we're really, really excited to have you here, and hope you find the experience helpful. All right, so our sponsors, I'm going to thank them very quickly. Our title sponsor, Innovate BC. Our gold sponsors are EY, Fasken, SFU BD School of Business, and UBC Sauder. Our silver sponsors are Vantech Angel Network, TELUS Ventures, and Volition Advisors. And our bronze sponsors are AceTech, BC Tech Association, Spring, and webnames.ca. So thank you very much to all of our sponsors. Fasken typically hosts a lot of our events in person. And we've always really appreciated that. Of course, this year is a little bit different in that there's no in-person happening, but we're still really glad to have their talent and speakers here. So that's the last slide here. If you do have any questions about the competition or any of the programs I mentioned briefly, please reach out anytime. Otherwise, we have Roger Kuipers and Ling Wong from Fasken, and I believe Roger is up first, so I'll pass it over to Roger.
Okay, I'm unmuted now. I was actually going to I'll make that go away. I was actually going to be on camera for part of this, but the hair, I haven't had a haircut in ages, so I just can't do that. Goodbye. So I'm back to the presentation. So it wouldn't be a legal presentation without a disclaimer. We're both lawyers, and most of the time we know what we are talking about. Sometimes we don't. Ling's actually quite good, but this really just goes to say that you know, this information is contained in this presentation is of a general nature. It's not legal advice and should not be construed as such. So, so let's start with an overview of what we're going to talk about this afternoon. We're going to focus on the 4 pillars of intellectual property, which are copyrights, trademarks, trade secrets, and patents. And so I'm going to talk about copyrights and trademarks, and Ling is going to talk about trade secrets and patents. Now, there are other types of intellectual property, plant breeders' rights and circuit topographies, but they tend not to be used very often, and so we're really focusing on the core 4, as we refer to them. Now, what we hope to accomplish in all of this, and what we hope that you take away from this, to the extent to which you're not already well versed in intellectual property, is to be able to identify what types of intellectual property, you know, what's copyright, what's trademark, what are trade secrets and patents, the differences. And then one thing that we're also going to focus on is ownership. One of the areas that the ownership is one of the areas that is one of the biggest traps in technology development. It's one of the issues that our clients have trouble with from time to time. So we're going to introduce you to some of the ideas of ownership in connection with each of these main types of intellectual property, and then talk about some of the risks and how to address them. And then finally, we're going to speak a bit about protecting intellectual property, both things that you can do practically to protect them, and also how you can obtain statutory protection for intellectual property by among other things, registering, getting patents, getting trademark registrations. So let's first talk about what is intellectual property. I mean, the intellectual and the nature of it helps to explain why it's different, and it also helps to explain why some aspects of intellectual property are problematic from a management perspective. So first of all, the intellectual part is that it represents intellectual efforts and achievements. So things like software, books, screenplays, and brands and logos and formula, recipes, business processes and inventions, new drugs, electronic goods, manufacturing processes. A broad scope of different types of products and services, but the common theme being that there's a significant intellectual component in their development. And so the property part of it, well, it means that it's something that you can own. It has commercial value, and typically ownership entails having a bundle of rights. So the owner has a bundle of rights to, for example, sell a product or a service, a right to prevent others from doing so, and handily from a commercialization perspective, the right to license others to use the rights that you own because of ownership. So intellectual property protection is quite important. Intellectual property can be a vital asset in corporate and financing transactions. So what Ling and I do from time to time is that when one of our clients is investing, or one of our clients is being invested in, or being sold, it's often the case, technology commercialization in Vancouver or in BC more broadly, it's like a relay race, and sometimes the initial few laps are run on campus, and then the baton is handed off to a spin-off company that runs, locally in Vancouver for a few laps and takes the technology a bit further and helps to develop it and protect it, file some patent applications, but as is usually the case, then the baton is handed off to a large international company or a US company that then pays often handsomely for the technology, but then takes it to market. And so the IP is often really important in those transactions. It's one of the things that gets focused on in due diligence. And it can often, if you don't have your IP ducks in order, it can be a point that can sometimes kibosh a deal. We've seen that happen before, not often, but sometimes. But it could also be a point on which you can get, you can get grinding on your price. So they can say, well, we were going to pay this, but we're uncomfortable about certain aspects of the intellectual property, so we need, a discount. So intellectual property also provides a competitive advantage in the marketplace, as I said in the earlier slides. It can allow your company to do something and prevent others from doing it. And it's a commercial asset, so it's something that appears on the balance sheet. And the act of managing and protecting intellectual property is also something that justifies the R&D and investments that are made. So, for example, if you approach investors and your use of proceeds has to do with developing technologies, they'll also want to know what it is you're doing to protect the intellectual property. Intellectual property can be a shield. Intellectual property can be an important part of company culture. If you articulate the importance of IP to your team and you show that that you value the IP they develop by protecting it, that's something that it's an important message to send. And the thing to remember in all of this, and what makes intellectual property kind of tricky, is that when you're dealing with other types of property, tangible property, let's say that you are a car manufacturer and you're building minivans, and well, why don't you build a minivan, you put it there out in the parking lot, and there's a fence around it, and it's tangible, it's difficult to steal. But as we know, intellectual property is very easy to copy. All sorts of different types of intellectual property. I use software as an example, to download, to copy, and to do that thousands of times because it's not difficult to replicate it. It's very easy to copy. So protection is very important. So let's just start by talking about intellectual assets and the value of intellectual property, because that's one of the struggles that our clients have from time to time is that whether it's investors or potential acquirers or others just don't understand the value of something that isn't tangible, that isn't real estate or other assets. But living in Vancouver, or at least working in Vancouver, real estate seems to be on the mind of so many here. So it's a good punching bag. So the slide you see right now is a survey. It's a table that shows the growth of value of intellectual property, intangible assets, as a total percentage of value of S&P 500 companies. So if we look at 1975, we see that intangible assets only valued 17% on average of S&P 500 companies. But as we fast forward to 2015, we're up to 84%. And so 84% of the value of those S&P 500 companies are brand value, trade secrets, patents, the technologies they have. Those are the things that make those companies valuable. The tangible assets, such as inventory and perhaps even real estate, comprise what's left of it, the 16%. So we're certainly dealing with something that's valuable and as a result, quite important. So let's turn then to the types of intellectual property. And one of the things that is important to understand about intellectual property and about your products and services is that intellectual property rights often cohabitate in services or products. And so I'll take a rather mundane example. This is Microsoft Office. And so typically when we do this presentation in person, I ask, what types of intellectual property do you think protect this software? But because of the technical constraints we're working in today, I'll just tell you the answers. So first and foremost, software is protected by copyright. So the software that comprises of Microsoft Office is copyrighted. Second of all, we have trademarks. Microsoft is a trademark, Office is a trademark. So when I said Microsoft Office, you knew what I was talking about. And when you say Microsoft, where it comes from, because as we'll see shortly, that's the purpose of a trademark, is to indicate the origin of goods and services. There are also trade secrets in Microsoft Office. You know that when you receive a copy of software, or if you access it through a software as a service model, you don't actually get to see the source code, the actual kind of intelligible instructions that show how the different modules of the software work. What happens before you receive and download software on your computer is it gets converted into binary code. And the process of doing that actually protects the trade secret, because the source code is actually a trade secret. It's something that should be protected. It's the magician's secret that once the audience knows, the trick doesn't have value anymore because anyone else can do it. And finally, Microsoft Office is protected by patents. Microsoft has one of the biggest patent portfolios in the world, and so they obviously value the ability of patents to protect their business and to also provide an opportunity to actually implement their technologies and knowing that they're protected. So I mentioned we're going to talk about the four main types of intellectual property: copyright, trademark, trade secrets, and patents. And so I'm going to start with copyright. And then what we'll do is at the end of each of those four sections, we'll have a moment where you can ask questions, or perhaps you can send them by text, and then we can answer them at the end of each section. And we'll also have some time at the end of the presentation to discuss to answer any further questions that you have. So let's start with copyright. So what is copyright? It's the sole right to produce or reproduce a work or a substantial part of the work. And the important thing to understand about copyright is that it protects the expression of an idea, not the ideas themselves. So for example, if you have an idea for a song where a guy's truck breaks down, his dog runs away, and his wife leaves him, that in and of itself isn't protected by copyright, and it's quite wretched. I don't think it's protected by any type of IP. But if you were to turn that idea into a song, write lyrics and have music, they would be protected by copyright, because they go beyond just an idea. They're actually the expression of an idea. So copyright protects what we refer to as works, and works covers a very broad scope of subject matter. So it includes articles and photographs, graphic design, study protocols, data, computer programs, website designs, sculptures, paintings, all sorts of things. Now, the three examples that I have in the slide show a number of things that are protected. The first one on your left is sheet music. So that sheet music and the music that's embodied by it is protected. And then if you move to the two other examples, one is the cover of Business in Vancouver, and the other one is an Expedia website. Those two examples comprise a number of different works. So you'll see Business in Vancouver, it has two photographs. So each of those photographs are protected by copyright. The overall layout is protected by copyright. The articles in there are each protected by copyright. And the combination of all those things together is protected by copyright as well. And it's the same for the Expedia website, except in that case, we've got a few designs which are already, which are also covered by copyright, like the Expedia design on the left, not the word Expedia, that's a trademark, but the actual design. So how do you get copyright? How does copyright exist? And there are two requirements, and one is a requirement of originality. So it needs to be more than a copy of another work. It needs to reflect the exercise of skill and judgment, but not necessarily creativity. Now, there are subtle differences between countries for what's protected, that formula, but this is the Canadian formula. And so the reason why I have the image on the left, which is some of you older folks like me will recognize as the white pages, that's the benchmark case in Canada for establishing when the requirement of originality has been met. And so in that particular case, they said if you take a bunch of people's names, arrange them alphabetically, and put their phone number, excuse me, allergies, that's all, just allergies. And if you put their phone numbers and their addresses next to it, that really doesn't take much skill or judgment. And so it doesn't meet the requirement. And so that's not protected by copyright. And that's what the case was about. Someone wanted to reproduce the information, and they were subsequently able to. And so by comparison, Van Gogh's Starry Night obviously beats that test. Now, the second requirement of copyright is fixation. And that's that the work must be expressed in some material form. I'll give you an example. If you're watching a live hockey game, so you're at, that may not happen until next September, or even if then, but just remember the good old days. You're watching a hockey game, and you see a bunch of people skating around and shooting the puck and all that. That's not fixed. It just happens, it exists for a moment, and then it's gone. But if you were to take a videotape of that hockey game, the videotape would be in fixed form, because it would be a kind of recording and something that would be something that would continue to exist. And so the videotape of the hockey game would meet that requirement, and then you would have something that's protected by copyright. And that's why, if you recall, if you watch through Hockey Night in Canada, it's the end, and they have the big copyright numbers there, and that's what they're referring to. Moral rights. This is a particularly tricky and problematic issue. and it doesn't exist in all countries. It's certainly in Canada, but not in the US. And it's often missed. But here's what moral rights are. You'll see the photograph on the right-hand side of the page depicts the atrium in, I don't know if it's still called the Eaton Centre, but what used to be called the Eaton Centre in Toronto. And if you look at the top of the atrium, there's a mobile sculpture. Those aren't actually birds flying through there. It's a mobile sculpture created by an artist of a number of Canada geese that are suspended from the roof of the atrium. And one Christmas, the building or the mall manager decided to decorate the geese by putting Christmas decorations on them. And the artist who created the mobile, despite the fact that he had sold and been paid for it, and so didn't own the tangible embodiment of his creation, succeeded in going to court and getting an order for them to remove the decorations. And the basis for that was moral rights. The author, so it's only the person, the man or woman that creates the work, has the right to prevent it, has a number of related rights, but the one we're talking about here is the right to prevent it from being modified. Another right that's within the basket of moral rights is the right to be associated with the work, so to have your name on it or to remain anonymous. And also, and this could be important, is how the work is used. So for example, if you paint a painting for someone, you're commissioned to paint a painting, and they take it and they put it in their home, that's all well and good. But if someone then takes that painting and then makes a copy of it and uses it as a background for ads for a political party, for example, or for businesses, you could object to that use of the painting for those purposes. And you would do so on the basis of your moral rights. So let's take that and put it within the context of your technology company. If you're one of the companies that's commercializing and developing software, and you have a programmer, and it's the programmer that would have the moral rights. And this is the tricky part of it. You can come up with the idea of the software, and you can come up with the architecture for the software, and you can tell all this to the programmer, but it's actually the software that the programmer programs in that the copyright protects. The idea, as you may recall, isn't protected. Now, if it's something you can patent or something that's a trade secret, then that's something that Ling will talk about. But now, add in that coder that you hired, whether as a contractor or even as an employee, has moral rights. And so imagine then that the coder, you part ways and you let the coder go, and then you go to create a new version of the software or an update or maybe even a bug fix or something. It's possible, although it doesn't happen every day. It's kind of an esoteric concept, but it's real. The coder could object to that. And as you could appreciate, that would be quite bad because it would really undermine your ability to continue to update and use the software. And so there's a really easy way of addressing that. And that is that in the contract you have with your employees and the contract you have with a contractor, you just include a sentence or even a part of a sentence that deals with moral rights. And so the phrase you use that's the silver bullet here is it's just the employee shall and does hereby waive all of his or her moral rights in the work product. I'm using work product here, just maybe you'll use a different term like the software or deliverables sometimes, but that's all it takes to get rid of it. So moral rights can't be assigned. They can't be owned by corporations. It's just the original author of the work, and they can only be waived. So that's the way you do that. So let's talk about ownership of the copyright then. As a general rule, the author of a work is the first owner of the copyright. So let's go back to my example where you come up with an idea for a killer app, and you even go so far as to develop the app, the architecture for it, you sketch it out in terms of modules and all that. It's actually the coder who comes up with the code that would be the first owner of the copyright to that work. And now the great thing is that if it's an employee, and if the employee is coding, to use the software example again, in the course of their work, then the employer, the company that employs them, will end up owning it. So from an employee perspective, ownership isn't terribly problematic, and you'll see that that is to a certain extent true for trade secrets and for patents. But as is often the case, if you use a contractor, someone who's not an employee, to make your website, for example, or to do coding, or the website is to an extent coding, then that work, it's actually the person or the company, or if that company has employees who code, that own the copyright. You don't, and so that it comes as a rude surprise sometimes, and it comes up in this circumstance. Sometimes a company will have a website, and they'll also use the website developer to host the site. And at a certain point, they may decide, well, no, we want to go to host somewhere else, use a larger company, some company with better uptime and all that. And the developer the website developer may say, well, sorry, you can't do that because I own it. And they would be on legal solid ground to do that. And that's really not anything that anyone intended. In fact, it seems quite strange. You came up with the idea, you paid for it. Why should that happen? And so that's something to be careful of. And it's something to focus on. You really want to look at copyright. And again, one sentence, whether it's in your contractor, your contractor agreement that says that the customer, which would be your company, will own all rights, title, and interest in and to the deliverables. Full stop. So you combine that with a waiver of moral rights provision, but in that case, you would say something like, the contractor will ensure that all of its employees waive their moral rights in full to the deliverables. Right? So that's two sentences, and you've sidestepped all of this potential trouble. So copyright protection, this is good for companies and artists and bad for lawyers. Copyright arises automatically. You should use a Circle C notice where appropriate. And typically you would put the Circle C next to the copyrighted work, along with the name of the owner and then the date of first publication, the date it was created. You can register. Registration is not expensive, but it enhances your rights. But typically, our clients don't register copyright until they're actually contemplating taking action against someone. And the reason for that, and by action I mean suing someone. And the reason for that is that copyright registration, the Copyright Act has statutory damages based, and the U.S. legislation does as well, that really sets out it's so many dollars per copy. And so you can appreciate if someone has taken your software code, put it in their software code, they've sold 10,000 versions of it, you just multiply 10,000 by the statutory amount, and you quickly come up with an amount that is pretty compelling if you commence action against someone, and should encourage them to settle. So copyright management, as I mentioned, focus on ownership and rights, in particular moral rights, and think about how works are developed, who would be considered the author, and focus on your contracts. What do they say about copyright, your employment agreements, and your agreements with contractors? And so when you have, here's the magic sentence to use with a contractor. So if you were to hire a company to develop a website for you, you would just have the sentence that says, contractor shall and does hereby assign to customer all rights, title, and interest into the deliverables, and shall ensure that each author of the deliverables waives all of his or her moral rights in and to the deliverables. So a bit of a mouthful, but you'd expect nothing less from lawyers. But there's your magic bullet. So any questions on copyright?
Hey Roger, we have a few questions. Okay, so one question is, can we use the C symbol automatically on our software if the owners have developed it without registration?
Absolutely. You don't need to register to use the C in the circle. What the C in the circle means is that you're just giving notice of your copyrights. And as I mentioned, copyrights arise automatically.
Okay, next question. If a contractor is hired to develop a product video, the person that hires that contractor provides the scripts, actions, and characters. Who has the copyright or moral right?
The copyright to the video is owned by the actual person taking the video. So, if the video has a script in it and the script was written or provided to the videographer, camera person, or company, then you'd have a situation where the deliverable that you would receive from them would, because I remember I showed you the Expedia and the Business in Vancouver examples, where you have examples where there are different copyrights, different works combined together. And in that particular instance, you would have the script embodied within something that they own copyright to. So it would really be kind of a combined work.
Got it. Okay, next question. How do we evaluate a recipe that has been very well received at taste tests and preliminary sales is the best way to protect to trademark?
Trademark won't protect the recipe. Trademark merely, and recipes are very tough. And what makes protecting recipes more difficult sometimes is that with some products, like if it's a recipe, you actually need to give the list to the people. So you're disclosing, sometimes a recipe can be a trade secret. And I don't want to get too much into that because I'm stepping on Ling's turf. But the short answer is no. Trademark, we're going to do trademarks next, and I think that it'll become apparent why not. The actual printing down of the recipe, like if you were to put the recipe down on a piece of paper, that would be protected by copyright. But then if someone mixed the order of the ingredients around and put it in a different font and changed the wording, maybe used ounces instead of ml and all that kind of stuff, then they'd have an argument that they're not infringing copyright because it's not a substantial reproduction. So yeah, recipes are definitely tough from an IP perspective.
We have 3 more questions. Do you have time to answer them now, or do you want to answer them later?
Yeah.
How long does a patent protection last?
Oh, that's for Ling. So Ling will answer that one.
Okay.
When we get them.
Okay. If I have an employee whose primary job function is not programming, but they are a widget at programming in their spare time, does that code belong to me or someone them?
It's a little bit of a gray area because it's not in the ordinary course of their employment. And when you mention the word spare time is not employment time. So if they do it at home on their home computer in the evening or on the weekends when they're not working, that supports the view that it belongs to them. So that's certainly something that I would want to straighten out in the contract.
And what is the downside of copyright registration?
I don't think there's a downside. And it's not, in the great scheme of things, it's not very expensive. It costs about $250, and the Canadian Intellectual Property Office doesn't even want a copy of your work. I think that they would, if they did, they would have warehouses full of manuscripts and things, and so they don't. It's just that a business typically has so many different copyrighted things. Every piece of collateral, every page of every website, every article, every report, the data. So it would just be onerous. But really, if you did have, if you're releasing an app, you could get registration for that, and it wouldn't just the app, and it would be something like $250, and you would have the additional protection, the ability to rely on statutory damages if you actually took action against someone for copying it.
All right. Okay, we'll move on.
All right. Well, we've entered the world of trademarks. It's a personal favorite for me, IP-wise. So as I mentioned, and I'll keep mentioning it because I think that this is the important thing to understand about trademarks, is that trademarks are used to indicate the origin of the goods and services. So they're not what you sell. They're the thing you put on what you sell so that people know that it comes from you. And so they can be words and designs, the shape of goods or their packaging. So the Coca-Cola bottle there, the actual shape of the bottle is registered as a trademark. Combinations of colors, the MasterCard, so the combination of orange or yellow, orangey yellow, and red in connection with credit card services is something that MasterCard has registered. So if you start a credit card company, you're not going to use the word MasterCard, but you're predominantly using the combination of those colors, then that's something that would infringe their rights. And the world of trademarks keeps expanding to include sounds and scents. Like, for example, in the US, I think the Harley-Davidson signature sound of the exhaust was registered. NBC, when the peacock shows up on TV, not that anybody watches TV anymore, but there used to be this 3-note sound or whatever, that's been registered. And there are a number of other types of trademarks that have been added, like an image that moves, but not like a movie or a video, but something that moves in a number of iterations. And so let's just talk for a moment about the value of trademarks, because they are the super valuable type of intellectual property. So there's this international consulting company called Interbrand, and every year they do a survey of the most valuable brands. And so what you see on the screen are the results from 2018. And so you could see Apple's at the top. Think about it this way. If you want to consider the value of the brand, when Apple comes out with something new, people get so excited about it that they camp out around the corner from the store for 3 days in advance. And so it started with computers, they did phones, they did iPods and all that. If Apple came out with an electric dog polisher, there's probably some people who would sit there and camp out because they just knew that that was going to be a fantastic, magical dog polisher, because that's what Apple does. And so that's how the brand has so much value. They put that on something, and people will buy it until they start putting out things that are bad, and they'll start to lose their brand value. Another thing to notice is you'll see that the most valuable brands now are internet property or IT related. There's a few older industries. Look at Coca-Cola hanging in there. Wonder how long that'll last. McDonald's clinging to the top 10. But by comparison, what I did here is here's 2015. So you notice there's a few people that are gone. 2018, and then so IBM's gone, General Electric's gone, and you can see Coca-Cola has gone down a couple of notches, while the internet-based properties have steadily marched up. So why are trademarks important? The goodwill associated with products and companies resides in their respective trademarks. What a dry statement. Let's put it another way. The trademarks are the things that your customers carry around in their head. And when they see it, they know it comes from you. And a trademark is like an empty vessel that you fill with meaning. So if you're Apple and you keep putting out these products that are disruptive and fantastic and immensely usable, you're filling up the Apple brand, the trademark, with that value. So, for example, if you were take White Spot, you could have White Spot, all of the White Spot locations closed. You could have all of the employees laid off. You could have the ownership change, or you could even have the company go bankrupt. And I wouldn't wish it on them. They're a good client, but and they could disappear. Like the whole thing could disappear for, let's say, 6 months, a year. And then if someone else came along and they opened a White Spot, and it was called White Spot, and they had pirate packs, and they had triple O's, and they had all of the designs and everything, people would go. And if the product quality was as good, then it would be like they didn't skip a beat, except they lost 6 months or a year. So you can see that how valuable the trademark is. You don't go to White Spot because, Jim's the dishwasher, or Ted's the waiter, or something like that. You go because, well, for recipes, but also because it's the connection to the brand, and how the brand positions itself in the marketplace, and because that's where you want to be in the marketplace if you're one of their customers. So let's talk about ownership. Ownership is quite different than other types of intellectual property. Let's say you come up with the great brand, you're in the boardroom, decades ago, of Tylenol, and you're a director, and you say, "I've got a great brand. Why don't we call the product Tylenol?" Well, if you were if it's copyright and you're the author of a work, you would own that. But for trademarks, there's only two ways you really own trademarks. One is you go out and register the mark. That makes you the owner. The other one is you use it in commerce. And so it's really the first person to use a mark in commerce or to register the trademark. And that's why it's kind of important to get a trademark registered quickly if you're going to start telling people that you're going to open a store and it's going to do this, and here's the trademark for the store. And then before you open the store, someone just swoops in and registers it. That's actually one of the lawyers we work with. When the Vancouver Grizzlies started, he had registered his trademarks for all the team names he thought might be possible. So maybe he had orcas and grizzlies and eagles or something like that. And it turned out that they used grizzlies, and there was this kind of awkward dispute that emerged when the Vancouver Grizzlies started playing basketball, and he ended up volunteering to give it to them. But you can see that happens. It happens increasingly in China, for example. We had an instance a few weeks ago, a couple of months ago, where we started talking to a lawyer in China about registering a trademark there. And then magically, a few days later, someone filed an application to register the trademark as someone unrelated to our client, and ostensibly unrelated to the attorney. So I don't know if they were listening in, or they overheard it, or it was a family member or someone. But because the first person to apply and register a mark is the owner, that's a big problem, right? It's a potential problem. So because use is so important, it being one of the ways to own a trademark, and ultimately, registrations, if you don't use a mark ever, at a certain point in almost every country, you can challenge the registration for non-use and have it struck out. So use becomes really important for trademarks. And so what is use in connection, use of a trademark? So we have, for goods, it's use. Use means putting the trademark on the goods, the packaging, or in any other manner so associated with the goods, so that notice of the association is given. So here's an example. You could see you've got Tylenol, it's on the pill, so that's use. But let's say you sell bulk goods. Well, you clearly can't put your trademark on a bunch of nuts, and then people put them into a bag, so you don't have the bag that's labeled. So you'll have the trademark on the sticker that goes on the bin. And again, I'm reminded another thing that we won't be enjoying for some time is the bulk food purchasing, but that was never high on my list of things. But you could see that in a situation like that, use is the closest way you can really get the trademark to the goods that are the bulk goods, is to have them on a label that's on the bin that people scoop the nuts from. Now, the difference between use in connection with services and goods is that services includes use in advertising. So if you advertise, if you see sometimes there's like a Coke and Pepsi challenge and an advertisement, and you think to yourself, how can Pepsi use the Coke trademark in an advertisement? And it'll say Coke, it won't have the design. It's because use in advertising doesn't count as use of a trademark in connection with the goods, but it does for services. So if you had two accounting companies and you had the E&Y challenge, and they were dissing PwC, they couldn't really do that because just using a trademark for a service, accounting, in an advertisement would be considered use, and at that point it would be infringing. So I know we're starting to get pretty esoteric here, but I'm going to bring it back to kind of regular practical stuff again. So picking a good trademark. We're going to talk about that and registration and then enforcement. So as I mentioned, a trademark's primary purpose is to indicate the origin of goods and services. So it needs to be distinctive. And there are two aspects of distinctiveness. It can't be descriptive. You can't have your trademark if you're coming out with a craft beer, it can't be beer because that doesn't distinguish anything. They're all beer. And it can't be confusingly similar with other competitors, with your competitors' trademarks. And so some of the most distinctive marks in history are things like Google and Apple for computers. Reason being that Google didn't mean anything. Yahoo didn't mean anything, like in the world of commerce. Apple didn't mean anything in the world of commerce, for computers, certainly for fruit. And so what happens is when you take something that's really distinctive, as in isn't really associated with anything except for your goods and services, that becomes a really powerful brand. Okay, so what are the two things you don't want to do if you want to make sure your trademark is distinctive? And one is you don't want it to be descriptive. And I'll explain. I mean, I already explained kind of like beer. Hey, it's our beer called beer, but there are other reasons as well. Let's say you're Volvo and you want to register safe cars as a trademark. Well, the reason why you wouldn't be able to do that is because it would prevent Toyota, Mercedes, and other companies from saying that their cars are safe. And so in that way, it could be used in a way that is anti-competitive. Fresh bread would be another example. You couldn't register fresh as a trademark in connection with bread because then potentially it would prevent your competitors from saying that they have fresh bread. Now, the exception to that is something like Save On Foods. Now, when I said Save On Foods, I'm sure almost all of you immediately thought about the grocery store. And you can imagine, though, when they first started out a grocery store and called it Save On Foods, that's not distinctive at all. They sell food and you save money when you're there. But there's this concept called acquired distinctiveness. And what that means is that some things, some trademarks, if they're used so long and so widely that they take on distinctiveness. So that when I say Save On Foods, you immediately think of the grocery store. And that's the exception. And the only reason I bring it up is because people say, well, you said a mark couldn't be descriptive. What about Save On Foods? Well, there you go. There's your answer. That's one less question answered. Confusion. This one's pretty straightforward. You don't want to pick a trademark that's confusingly similar to those of your competitors. Here are a couple of main reasons they could sue you. And the second one is then your customers may end up buying your competitors' things thinking that they're yours or vice versa. So that's not good. But here's something that's important to understand about trademarks, especially when we're talking about, confusing, similarity, is that trademark rights are specific to an area of goods or services. So I've got the examples of Delta, Delta, and Delta. Now, one is an airline, and one is a hotel, and one is a brand of faucets. And so, although they're identical, no one's going to confuse a faucet for a hotel or a hotel for an airline. So that's an important principle. So if there's another brand that, for a good that you really like, that's completely unrelated to what your company is doing, then maybe it's okay. So the second part, once you've come up with a mark that isn't descriptive, that isn't the same as someone else's mark, or at least you don't think it is to do some searching and clearance. And so you can search trademark registers, and then you can do searches. Now, you'll recall that I mentioned that rights arise not just through registration, but also use. So if you come up with a trademark and someone in Flin Flon, Manitoba, not the disc Flin Flon, Manitoba, has been using that mark there and nowhere else, and in the same area that you propose to use it, they may have rights. And you wouldn't know that by looking at a trademarks register. So we do some common law searching as well. And here's a tip. Registering trademarks can be expensive, not nearly as expensive as patents, but certainly it's country by country most of the time. And so if you plan to sell goods and services in a number of different countries, that can get expensive. And one of the ways you can contain that cost is you can focus on having a house brand. So for example, if you look at BMW, they have the main BMW brand, and then they have a bunch of numbers, the 3 Series, the 2, 335, 340. They don't have any rights to the numbers, but all the goodwill and the distinctiveness is in the main brand. And so really, if you're starting out, don't have a lot of money, you may want to just focus on having one main brand, and I'm using brand and trademark interchangeably here, for the company, and that way you can save a lot of money. So for trademark searching, I'm just going to move quickly through these. You could do knockout searches, full availability searches, and investigations. The knockout searches are where you start. And so here is the site from the Canadian Intellectual Property Office, where you can enter the trademark in and hit search. And that'll show you right off the top if there are any identical marks that have been registered or applied to be registered. Now, there are a couple of warnings with that approach. One is if your trademark is great, G-R-E-A-T, and someone registered G-R number 8, you're not going to find their mark, but because it is phonetically identical, it would be an obstacle. So that's something to bear in mind, is that the search function here is only on the exact spelling, and confusion, if there are 3 dimensions of confusion you have to avoid. One is, it doesn't look identical or confusingly similar, but the other one is phonetic, and one is connotative. So it also can't evoke the same idea. So that's something that's not going to show up in a knockout search. And this is the US one. This is the USPTO website, so you can go there and do the same thing, enter the term and see. And so really, we call these knockout searches because, what's a good idea is you come up with 5 trademarks you like, and then you just run them all, and a few will not get knocked out because there's an identical hit. And remember, it should be an identical hit in your field, because if it's for faucets and you're in software, then you're not going to have to worry about it. But again, we're not ruling out that someone's using it, and that's why we look at other searches and that are a bit more comprehensive, and of course they're more expensive. So you whittle down your list of 5 trademarks into maybe 2 that look really promising, and then you do the bigger searching for those. As I mentioned, registration is by country, except the EU, which is now 27 states for the price of 1. It used to be 28. In Canada, it says 1.5 years average for registration. Canada has become the Canadian Intellectual Property Office largely because of a bunch of changes they made to trademark practice in Canada last year. It takes a long time. So when we file a trademark application now, we don't expect to hear from an examiner for almost 2 years. So I need to update that. But the good news is that the price is still about the same. So in Canada, it costs about $2,200 if you're in 1 or 2 classes and you don't get opposed and you don't get any examiner objections. And that's where an examiner says, oh, sorry, you can't register your trademark because it's descriptive, or you can't register your trademark because it's confusingly similar to someone else's prior registered or applied trademark. So, so finally, in addition to trying to save money through just focusing on a smaller number of marks or one big house mark, is that I would recommend that you prioritize countries, because if you're going to do registrations and you're going to do searching in other countries, it can get quite expensive. So what you could do is you can prioritize the countries by the value of their market and the likelihood of your entry into those markets. So finally, enforcement. The Canadian Intellectual Property Office doesn't police your marks. It's something you have to do. So you have to watch out for infringement of your rights. You should take action against infringers, and typically that starts with a cease and desist letter. We write a lot of those. We call them crapograms. We send them to people, and we threaten all sorts of litigation and horrible things, and they usually agree to stop infringing. But if they don't, then you can go to litigation. Or if you notice someone's applied for a mark that's similar, and if the examiner does allow it to be published and does let it get past examination, you can oppose that application to try to stop it. So just to sum up, pick the right trademark. I've already mentioned, maybe you start with 5. Here's kind of one practical organizational behavior aspect to it. If you only have one trademark, what often happens is our clients, there's a fair amount of kind of internal vetting that goes on before they come to us and say, here's our trademark, can you do some searching? And what happens in the interim is that people have some kind of an emotional buy-in to the trademark, which is completely natural, and they start seeing the company or the product under that brand. And then what happens is that when we come with bad news, if we say to them, well, someone's already registered a mark like that in a different country, the US, Canada, an important country for them, that because there's that emotional buy-in, they're reluctant to heed the advice and rebrand, and sometimes people just kind of march on. And that's why a really good approach is to really just consider more than one potential trademark and see which one does best in the clearance part of it. Register trademarks. Registration gives you much better rights than unregistered marks. There's something called common law trademark protection in some countries, but it's not very good. Use it or lose it. As I mentioned, trademark rights are ultimately dependent on use. And so you need to use a trademark. And if you don't for a few years, then people can challenge it and register it themselves. Coach is one example. You'll know Coach is kind of a higher end company that specializes in bags. And that was actually a trademark used by a company a few decades ago that went out of business. And some, private equity group got together and said, hey, let's, we'll do this business, so we'll use this old brand, and we can, because they hadn't used Coach in some time. But it still had some, hold on the consuming public's mind, or at least I guess the older members of the consuming public. And so they were able to scoop that up and not pay anything for it because the rights had gone. And that's it for trademarks. Any questions?
Yes, there is. Okay. Is trademark insurance an insurance that covers the trademark enforcement?
Oh, that's a very good question. I haven't encountered trademark insurance. It may very well do that. That's interesting. I'm sure there isn't any, kind of risk that you can't find insurance for. So I assume that it is, but I don't know for sure.
Okay, what is the recommended strategy for a startup to protect their trademark in Canada and abroad? Costs generally seem prohibitive as they pile up in each country.
Yeah, very good question, and that's where I try to focus on is to be practical with respect to costs and reduce costs. So have fewer trademarks, maybe even have one. Be selective in the countries that you apply in. But here's a little trick that actually is quite useful. You can, and this is even better in the world of patents, but you can apply to register a trademark in Canada, and then you have, for many countries, particularly the most important countries, you'll have 6 months within which to file a trademark application there. And then that trademark application can claim your Canadian filing date, which means that if someone in in the EU applied to register for the trademark there within 6 months of your Canadian filing date, and then afterwards you filed for an EU registration, that your claim of priority would protect you. And that would mean that your application in Europe, although it's filed later than the other one in Europe, you should prevail. So that buys a bit of time. Good clearance, obviously. I mean, do lots of searching, because what's really expensive is if you go down the road and you adopt a trademark and you build some goodwill in it and you put some money into registering it, and then it turns out you have to rebrand because it's too close to one of your competitors' marks, right? So good clearance is also a way you can avoid unnecessary expenses. That's it on that question.
All right. Does copyright help and build and protect your brand before you register a trademark?
Well, copyright and trademarks are distinct, but here's one area where they overlap. If it's a word mark like Pepsi, that's not protected by copyright, but copyright does protect designs. So if you have a fancy label design with a swoosh and a few different colors in it and all that, copyright can protect it. But you do have some common law rights if you start using your trademark. So all is not lost until you have registered it. But the one thing to bear in mind is that so many of our tech sector clients aren't in the marketplace. So they've come up with a brand, but they're not selling services, they're not selling goods yet. So that means that they're not even using the mark. And so you can go for, let's say you go for a year of the rounds saying, this is our company and this is our brand. And then, but you're not, because you're still working on the product or the service, you're not using it. And if you haven't applied to register it, you're very vulnerable, because someone else could walk in, take that trademark, start using it in commerce or apply to register it, and they would be entitled to do so.
Okay, we have some more questions. Do we have time to answer them now, or do you want to answer them later?
I'll defer to Ling. Sorry, that
Okay.
poses an issue for communications because he's not online right now. I'd be happy to stick around and answer some more questions. And how many are there?
There's about 5 more at this point, if that works.
Maybe let's do a couple and then we'll move on to Ling.
Okay.
And then
Okay, sounds good.
I'll try to speak quickly.
All right. Okay. If your client uses your product with the trademark in testing and does not pay for it, is it used to to commerce, therefore protected?
If they use it and they don't pay for it?
Yeah.
Well, if you used it first, then their use would be infringing. But as I mentioned before, if they take your trademark, use it in commerce, you haven't used it, then you've got a real issue, because then they're first in market. Unless you've applied to register it before they used it.
All right. Okay. Is the application date for a trademark the most important?
It is if you don't have use of the mark in commerce and someone else either used or applied to register the mark around the same time.
Okay. And I have a few questions. People are wanting to know if you can repeat or the wording that you used about contractors waiving their rights.
Oh, that's in the materials that you're circulating.
Okay, yeah, that's what I thought. Okay. Okay.
If not, they can just send me an email. I'll be happy to send it for free.
Okay. Okay. And all right, do you want to answer one more, or are we ready to move on?
Just one more.
Okay. Is there added value in having a US trademark on top of a Canadian trademark if we are not selling in the US?
If you're never going to sell in the US, and this sometimes happens with goods and services that are regulated jurisdictionally, like sometimes thinking about insurance or real estate services or something, maybe not, but it'd be nice not to have someone in a neighboring market. Like, let's say that they took your trademark, used it in the US, went bankrupt, ripped off a bunch of people, you could have some kind of deterioration in goodwill that would occur, that you would perhaps avoid, because we're very close to America, and so yeah, you don't have to. It would be helpful.
Thanks, Roger. Okay, Ling, your screen is up.
Okay, hi everyone. So I'm going to talk a little bit about trade secrets, and then follow up with patents. And just a qualifier, bear in mind that a lot of what we're going to talk about today really is intended to give an introduction and an overview to these forms of IP. It's not going to be exhaustive, but hopefully it's going to give you enough information at least to be able to identify and flag issues as and when they come up. Now, regarding trade secrets, these are generally used interchangeably with the term confidential information. I think technically, trade secrets are really considered a subgroup of confidential information, but for sort of general purposes, they're essentially treated together. And there are certain requirements to qualify as a trade secret, and I've shown those on the screen there. So basically, what we're dealing with is information that's not that belongs to a company that's not generally known outside of that company. And secondly, that information has commercial value because of the fact that it's kept secret. And then thirdly, probably most importantly, reasonable efforts have been taken by the company to maintain the secrecy of that information. So those are the sort of the core requirements for something to be considered a trade secret. I've just listed a few examples of potential trade secrets here. So these could be things like maybe you have a process within a manufacturing facility. Maybe there's some know-how that you know of but is not generally known to your competitors. Maybe something like a secret formula or even possibly a recipe. But it also encompasses a lot of, I would say, sort of more commercial types of information. Things like customer lists, supplier information, marketing plans. So all these things potentially can be encompassed by the term trade secrets. Now, when we're talking about trade secrets, there are a number of advantages that spring to mind. The one being that as long as you keep that information secret, trade secret doesn't technically really expire. And so, in theory, these could be, in terms of its lifetime, it could be indefinite. And so that can be a very significant advantage for something that you keep as a trade secret. Secondly, you don't really have to file for an application or seek a registration or go to government to get approval, unlike some of the forms of IP that we're going to talk about today. Things like trademarks and patents. Those you actually have to take an active step to apply. In the case of trade secrets, as long as you've taken the appropriate measures, you should have something which qualifies as a trade secret. And as I've shown, there are some examples of trade secrets which have been and are very successful. Things like the Colonel's secret blend of herbs and spices for KFC chicken, the formula for WD-40. All these things have been protected as trade secrets, and they remain so. If, as you'll find later, and as I'll discuss, if they had been protected with other forms of IP, for example, if they had applied for a patent for the formula for WD-40, you have a very definite term there, up to 20 years of protection. And once that 20 years is up, then it's open to the public, and so you can't protect it anymore. But in this case, these trade secrets have been protected successfully. I often think of trade secrets as a sort of do-it-yourself form of protection, because as long as you've taken the appropriate steps, they can be, in some instances, very elaborate steps. and expensive steps, but you don't have to go through an application process or go to your lawyer to really prepare any sort of formal documentation or anything like that. Now, on the other hand, there are certain disadvantages associated with trade secrets. The obvious one being that once the cat is out of the bag, if for whatever reason you share that information with someone else, or perhaps that information is obtained by someone else and it's published, if it's put on the internet, for example, then it's too late. You can't put it back in the bag, and once it's gone, it's gone. It's no longer a trade secret. Another significant disadvantage is that we cannot prevent competitors from coming up with the same solution that we've come up with. And even in the case where the competitor reverse engineers your product or tries to figure out how you do it, if they are successful in achieving that same solution, you can't do anything about it. Subject, I say, to contractual provisions. So, unless they've unless they were perhaps a collaborator with you and they discovered the way you did your formulation, generally speaking, you wouldn't be able to stop a third party from independently arriving at that same solution. And then a significant risk in some situations where you're dealing with perhaps more technical know-how. There's a risk that if that subject matter could have been protected with a patent, but you decided not to go down that route, you decided to keep it as a trade secret. The risk is that a competitor might independently come up with that solution, and they may actually apply for a patent and successfully obtain a patent. In which case, they would be able to enforce that patent against you, even though that was something that innovation was something that you actually had come up with yourself. So there are certain risks associated with trade secrets, but I think they, in the right situations, they can certainly be very appropriate and valuable. Now, I will very quickly touch on ownership here. In the case of a trade secret, the situation arises much as Roger mentioned earlier. When you have an employee or an external contractor work on something that relates to your business, and they come up with a technological solution, the question is, well, who actually owns that? And I think the take home here in respect of trade secrets is that if you obtain a written agreement that expressly says that whatever rights are being developed or have been developed automatically go to the company, or you have some sort of agreement after the fact where those rights are expressly assigned to that company, that essentially is going to get you out of most potential disputes. A lot of the disputes that arise in this context really are due to the fact that maybe an agreement wasn't put in place, or there's some sort of uncertainty, and it's usually when you have that uncertainty that you have misunderstandings, and as a result, potential disputes. And so, if there is anything that in terms of a takeaway here, is that if you get everything properly papered, that's going to help you avoid a lot of the potential risks. So, in the case of an employee, if you have a employment contract that expressly spells that out, or maybe you have a contractor that you're working with, you get them to sign a suitable subcontractor agreement which has those types of provisions, then you should be in pretty decent shape. On top of the actual ownership of the trade secret, there are a number of other sort of rights which will typically flow from that, or usually will be dealt with in those agreements as well. Things like, if I share this information with you, what are you allowed and not allowed to do? Things like, obviously, you can't disclose it to other people. You can't make use of it outside of its original purpose. And as a result, you are effectively adding extra layers of protection to that trade secret on top of the pure ownership question. Now, I mentioned earlier that you do have to take reasonable efforts to protect your trade secret. And that's the case for most countries where they have a trade secret regime. It's not just a case of you saying, oh, that I consider to be my trade secret. You do have to take appropriate measures, and there's no sort of secret formula here, unfortunately, and it's really determined on a case-by-case basis. So, as long as you can evidence and show that something that you had was treated internally as a trade secret, and that it was intended to be as trade secret, and it was shared with another party as under the terms that would indicate that it was a trade secret, those sorts of things will help you establish that it was always considered to be a trade secret. And in conjunction with that, as a result, even though I said that earlier, trade secrets are sort of the DIY, do-it-yourself form of protection, in practice, you do have to have appropriate trade secret management policies, and ideally, to have some program in place where you are spelling out exactly how to treat this category of intellectual property. Now, how do we actually protect the trade secrets? I've provided a short sort of summary here, but essentially, as with many forms of IP, the key here really is firstly identifying what you have. And there's it goes without saying, if you don't know what you have, you can't really take steps to protect it. So the first thing is to continually monitor the developments and the innovations that come through from your R&D staff or from other areas of your company. One, to continue monitor and identify that and say, well, hey, we've got these interesting innovations here. They may be valuable, they may not be. What do we want to do with them? And is there anything that we have to put into place? So the first thing is actually identifying it and categorizing it and say, okay, this is something which we should be treating as a trade secret. This is something which is probably not a trade secret. Maybe we want to consider other forms of intellectual property protection for it. Internally, as I say, the ideal is that you have policies that are that lay out in pretty express terms how to deal with these potential trade secrets. The key here really is to educate your own staff how to actually deal with it, but also it should teach your staff how to deal with it to other parties. So in a practical context, a lot of companies are collaborating with other companies. They may have projects with competitors, and they may have projects with potential customers. A lot of these things will involve sharing of information, and as a result, you really want to make sure that your policies are pretty clear, so that there's no sort of leakage of information, or there's no inappropriate leakage of information, and so you can maintain that secrecy. The general point here is to mark any documents that you have which embody any trade secrets. And again, this is really for warning purposes. It's to let your employees know this is potentially valuable information. Don't leave it lying around. Don't take it home with you. If you have to share this with someone, is that someone that's suitable or has a need to know that information? And so the fourth point here is just to restrict general access to the extent you can. It goes without saying that if you have stuff lying around that evidences your trade secrets, then there's a high risk that that's going to get out. And if you go back to some of the situations I mentioned earlier, so for WD-40, for example, apparently nobody knows the full formula for WD-40. I think it's, at least historically, it was broken up into two separate parts or two separate halves of the formula. And I think two people knew half of the formula. And, there's not only is it sort of limited in that respect, but the company took pretty extraordinary measures to actually protect that information, by putting it into safes and various things like that. So, that's a fairly extreme example, but the general recommendation still applies. You want to limit access, and and make sure that that information doesn't get out inadvertently. I've listed some specific situations for protecting trade secrets in a computer context. I'm not going to go into too much detail. I think they're pretty self-evident, but in this day and age, a lot of the information we have, if not all, is digitized in one form or another, and so as a result, it's quite easy for that information to get to be disseminated or be removed or even copied. And so these are just some I guess pointers in terms of what to keep in mind. When we think about trade secret protection, we're always generally concerned about external threats. So things like hacking or burglaries or losing devices. That's part of the problem very often. But the reality is that any situation where we have trade secret loss, unfortunately, it's an internal matter. It's either employees inadvertently or maliciously sharing that trade secret information with others. In some cases, maybe subcontractors or contractors, and so you have to make sure that you have those trade secret management policies in place to kind of alert everyone involved in that chain. Finally, in terms of enforcement, so assuming that you have taken the appropriate steps to protect that trade secret, and you've taken reasonable steps to treat it as a trade secret, the advantage is that you can potentially sue a third party for theft of that trade secret. So in the situation where, as I say, you maybe have a disgruntled employee, they try to, upon leaving the company, they try to take some of the company's secrets with them. You can, in theory, go after them and enforce that right. As I say, assuming that you have taken all the appropriate steps in the first place to have it treated as a trade secret. And that's essentially it for trade secrets. So I don't know if anyone has any questions specifically on that.
Yeah, okay, we have one question right now. Kind of touched upon this, but what prevents former employees from taking advantage of a business opportunity that they had explored while working for the company? I thought in Canada, employees are allowed to benefit from the type of work on the job knowledge.
Yeah, that's a tricky question in that it really will depend on the particular fact situation. When you're talking about business opportunity, I think it will depend on to what extent that came to because of the fact that employee had access, whether it's to a, I don't know, maybe it's a good customer of the company, how they actually came about that business opportunity. If it was directly related to the company, then there's a there's a possibility that would be considered a sort of a breach of the fiduciary duty. It depends on the nature of that employer too. So I mean, think of a situation where you have someone who, maybe it was a former founder of a company. Maybe they decided, I've decided to leave this company and start my own separate business. But they have acquired certain, I guess, opportunities in the past, and they've decided to build upon that. That potentially might be treated as a sort of breach of fiduciary duty. So really, the opportunity belonged to the company, but you have an employee, in this case, a trusted individual, benefiting it or taking advantage of it for himself. I think ultimately, can't give you a clean answer on this, but it really depends on the particular fact situation, I'm afraid.
Okay, would published academic formulas used in new novel ways be considered a trade secret?
Sorry, could you repeat that?
Okay, sorry, I just removed the question. Kevin, can you just re-ask me that? Sorry. Or actually, no, I can. Yeah, sorry, Kevin, can you just re-ask me that? And then I'll ask Ling.
Yeah, we can
okay,
take it at the end if you wish.
Yeah.
We'll have time.
Okay, is there a high burden of proof of infringement, and how many companies proved like infringement?
Sorry.
Yeah. Arjun, can you re-ask that question in a little reworded way? But yeah, that's all the questions for now, Ling, if you want to move on.
Okay, yeah, we'll circle back on those at the end, if that's okay.
Okay, sounds good.
So going to talk a little bit about patents now. So the situation generally is, your company may have come up with a particular invention, and this might be an innovation that makes your product or service better, cheaper, faster. At least to some extent, it provides your company with a competitive advantage. And the goal here, as I say here, is to really prevent competitors from using that same technology. So in essence, claiming ownership of that and the exclusive ownership of that particular innovation. The problem typically is that if you disclose your invention or make it available to the public, once others see it, then it really is available for other people to make use of, unless you've taken steps to protect it. And the way we typically would do it in the case of where you have an invention is through patents. And when we talk about patents, so patents really protect inventions, and inventions have a specific definition. But ultimately, what we're concerned with are, I would say, functional aspects. So really, how something works or how something is done. And if you have something which can be protected by a patent, it can be very powerful, because under a patent, you have the right to prevent others from making, using, or selling that specific or claimed invention. So in effect, what you're doing is you're blocking competitors from moving into a certain space. And as a result, of course, that's going to provide potentially a very significant and valuable commercial advantage. A patent can last up to 20 years from the date that you file the application for a patent. And so, depending on the industry involved, that could be a very long period of time. In some industries, that may be considered a very short period of time. So it really depends on the industry, but in high tech, for example, 20 years is a lifetime. So that's a very significant period of protection. The proviso here is that in order to have this exclusivity, in effect, it's a bargain with the state. So in exchange for fully disclosing your invention and sharing it with the world, you're given this 20-year period of protection. And so as part of the bargain, you have to make sure that you really do fully disclose your invention. You have to teach the world, in effect, how to make use of it and how to put it into practice. There's no if you go through the process thinking, I'm going to share it with the world and apply for a patent, but I'm going to try and hide parts of it so that my competitors can't really make use of it. If you do things like that, that potentially can put the patent at risk. And so the general approach is that in order to be able to qualify for that patent protection, you do have to fully disclose the invention that you have. In essence, a patent, very, very, very simply, is a document that describes your invention and how to put it into practice. So it's a fairly detailed document. It goes into fairly extensive detail to talk about the problem involved. What is the problem? What's the issue that we have, and how is the current state of the art? How do people traditionally deal with this problem, and how are we now coming to this problem, and what's the new solution that we've come up with, and how does it improve upon what other people know? Typically in a patent document, you include a lot of you included a fairly detailed description of how all that works together. So you actually say, look, this is what I do, this is how to do it, here are the limitations, here are the variations or alternatives that you could adopt. So in essence, it is a very detailed document that that outlines your own invention. At the end of every patent document, there is probably the most important part of the patent, which are the claims. So the claims really are the stakes in the ground, if you like. So that's what you have protection for. So at the end of that document, the end of that description, there are a set of claims which spell out exactly what we consider to be the invention and what, if we are successful in getting that patent, what competitors cannot do. And so the claims really, determine the area of protection here, and then that's why they're actually key. A couple of points here, just to bear in mind, even if you are successful in obtaining a patent, there are certain things that you don't get, unfortunately. One is that freedom to operate is a related issue in that, okay, well, I've applied for a patent, I've discovered this this new technology, maybe it's a new process for creating manufacturing a drug. It doesn't always follow that you have freedom to operate. And the reason for that is if you come up with a new innovation, yes, it might be something that's patentable, but if in practicing that invention, you actually infringe someone else's patent, then you don't have freedom to operate. An example I sometimes think about is, if someone had patented a table, and you decided to you discovered a folding table, that would probably be considered patentable because it's a new innovation. But if in making your own folding table, you actually have to infringe upon the competitor's normal standing table, potentially at least, you might not have freedom to operate. And so that's something to keep in mind. A lot of people, when they are looking at patents, they sometimes confuse the rights under a patent with freedom to operate, but that's not always the case. And so that's just something to keep in mind. Secondly, even if you are successful in obtaining a patent, it's not automatically enforced. The government doesn't enforce that patent for you. You really have to act as your own patent police. And so you have to sometimes keep track of competitors, what they're doing. And so if you see that they're using something which looks to be very similar to what you've patented, you have to actually, unfortunately, go to court to enforce those rights. Very quickly on the issue of ownership. So much as we discussed before, in the patent area, the person who comes up with that invention is presumed to be the owner. And so in the case of maybe an employee or some subcontractor, if they make something, even if it's done for the company, the presumption at least is that they're the first owner of that invention. And there are a few provisos here. So unless they have some sort of express agreement to the contrary. So in the case, for example, for an employee, if the terms of employment spell out that that anything that they come up with that's patentable belongs to the company, then you're okay. And I think, and in the case of a subcontractor, it's much the same. You'd have to look at the provisions of that contractor agreement to see whether ownership is properly dealt with. And so again, the takeaway here is that if you do have those provisions and it's expressly provided for in a suitable agreement, then you're out of the water, I would suggest, in most cases. In the situation where there's no express agreement or the agreement is silent, then you have to unfortunately go through a set of tests to determine who actually owns those rights. I think very often the presumption for the company is that, well, we paid for that, or we asked that person to do research on that area. It should belong to us. You have to sort of treat that with a bit of caution. And so, as I say, rather than rely on the fact that you had an employee who was hired for the express purpose of coming up with that solution, much better just to rely on a contract provision somewhere in his agreement. So yeah, that's in essence the takeaway. You know, it's much better to deal with it upfront than to have to you know, go and examine the employer relationship to see what they were doing. You know, what were the sort of terms of employment, what was he expected to do. You know, all that unfortunately brings in a lot of uncertainty. So so if you can look at some sort of agreement, then you're you know, you'd be better advised to rely on that. So when it comes to actually obtaining a patent, there's a number of steps. So the first really is secrecy. I'm just gonna put these out. So the first step generally is to keep it secret. And then we're gonna go into a bit more detail about this later on. But essentially, the first step is to keep it secret. So until you're ready to potentially consider going through the patent route, you really wanna make sure that it's kept secret. That the first step generally then involves assessing the patentability of what you have, and then assuming that you do have something which is patentable, you know, that you can proceed with the first step of applying for a patent, and then that patent application process typically involves a first filing, and to the extent you might be considering other countries, there may be follow-on filings in other countries. Examination is a part of the sort of granting process. Examination really involves presenting your case to an examiner to convince him that what you're applying for is indeed patentable and you should be granted a patent for it. If you're successful ultimately in getting through that process and you get a patent, you know, then you have essentially a commercial asset on your hands, and you can do with it how you like. You know, it may be that you decide to keep it to yourself and just use it within the company, but you can certainly commercialize it in other ways. You may decide to license it to other parties, or if you're not using it at all, you know, you might actually consider selling it or signing it outright to another company. So in terms of keeping this invention secret, there are certain requirements here, in that if you've come up with an invention, generally speaking, any public disclosure of this will start the patent clock running. And so in essence, you have to file the patent application for that invention before you publicly disclose it. In many jurisdictions, not all, in many jurisdictions, there is a short grace period. In Canada and US, for example, there's a 1-year grace period, which means, let's say you go to a trade conference and you share your invention with the attendees at that conference, you basically then have 1 year within which to file a Canadian or US application. Otherwise, it's too late and you're out of luck. So any time that you are considering publicly disclosing your invention, you know, you have to be kind of mindful of this, and you have to say, well, okay, well, is this something that I will be patenting or consider patenting? And if so, you know, have I put the measures in place to keep it protected? Yeah, I did say that so any public disclosure of this invention was going to start that clock running. There are ways to keep it inside the company or not start that clock running. So in many cases, if you do need to share your technology with other people, you know, the typical way to do it is through confidentiality agreements or non-disclosure agreements. If you're sharing it with a third party, maybe it's, you know, someone who's going to put your app into actual practice. Maybe they're the programmers that are going to put it into action for you. You know, if there is a suitable confidentiality provision or an NDA there, then you're still fine. It doesn't start the clock running. But anytime you do, as I say, you know, do be very mindful of this, because, you know, we do encounter situations where clients come to us, so potential clients come to us and they say, look, this is something that I've been working on for a while. You know, we think it's going to be pretty disruptive, only to find that they've unfortunately previously disclosed this to other parties, and which means that they're not entitled to actually even apply for patent protection anymore. So we're going to now go through some of the requirements for patentability. So in order to to get a patent, there are various requirements. The first is novelty. This is fairly straightforward. It just means basically, has anyone else come up with this same solution? Is this new? This is usually a fairly easy question to answer. You can very often I guess investigate other competitors. If you know that no one else has come up with this solution, then the chances are what you have is novel. The tricky question very often is that the second requirement is that what you have has to be non-obvious. It's a bit of a tricky question because what that really means is that, so even though your invention is different, it's such a minor tweak on what is already known that it would be considered obvious. That as I say, that's a fairly difficult question to answer sometimes. But what you basically need to do is have an appreciation of what the prior art is. So what is the current state of the art? What does someone who's skilled in the art know already? And in light of all that, is your invention, would your invention be considered obvious or not? A very bad example I sometimes use. So if you have someone who's patented or someone who's come up with a four-legged table, so four-legged chair, let's say, and you decide that a six-legged chair would be a great invention because it's so much more sturdy than a four-legged chair. Yes, that would probably be new, but it certainly wouldn't be. It would certainly be obvious because any person skilled in the art, someone like an engineer, would certainly know to apply some extra legs for sturdiness. So. But that usually is the trickiest question to answer in any sort of patentability analysis. Third requirement, it has to have utility. In other words, have a useful function. It's a very low threshold that you have to meet. So basically, if you've got something which has a useful function and it achieves that function, then generally you're okay. So it's the novelty and inventiveness which are the real questions that to come up. And the fourth requirement is that it has to be appropriate subject matter. So there are certain things that you can get patent protection for and certain things that you can't, which are expressly excluded. And so we will have to go through that analysis anytime we have a potential new invention. Now, in terms of subject matter, the statutory definition is that any new and useful art, process, machine, manufacture, or composition of matter, or any new and useful improvement thereof can be the subject of a patent. But I've listed some of the more traditional areas here, maybe things like pharmaceuticals, maybe it's a machine or some other form of mechanical device, maybe it's an industrial or manufacturing process, chemical compounds. Those are the more traditional forms of patentable subject matter. On top of that, we also have computer software and business methods. These are more, I would suggest, non-traditional forms of patentable subject matter. In the case of computer software, there's a bit of a debate going on in terms of how and whether computer software should be patented or not. I think the short answer is that computer software can be patented, but certainly anytime you have computer software or computer implemented inventions, it's almost certainly going to be scrutinized. And so they're not straightforward, but they can be obtained. Business methods in general, I would say, are a little bit more tricky to obtain, but again, depending on the way in which the application is framed and how it's, I guess, presented to an examiner, that potentially can be obtained too. There's certain absolute exclusions here, things like scientific principles, algorithms, mental processes. These things are kind of excluded. If you have a discovery of equals mc squared, that's just a scientific principle. Unfortunately, it's not a patentable invention as such. So as I say, the patenting process itself is it's fairly complicated, but essentially it starts with preparing and filing one patent application. once you have that application in place, once you file it with the Intellectual Property Office, it sits there for a while, and then at some point, a patent examiner is going to pick up that application and conduct a search to see if your application meets with the various requirements that we discussed. So is this something which is novel? Is this something which is non-obvious? And so as a based on that assessment, he's going to issue a report which says, hopefully it says, yes, this is just perfectly fine. You should be entitled to a patent for this. But more typically, he may find something which he thinks is very similar to what you're applying for, and he might issue a preliminary objection. And so that gives us the right then to argue against his position. So very often, his initial position may have no basis. So for example, maybe he's misconstrued our invention in relation to what he's found as prior art, or maybe he's misunderstood the prior art because it's in a completely different area, and so it operates in a different context to our invention. And so we have an opportunity to argue against his position, and if his position is not without basis, if we have to, maybe we'll need to amend our application. And so that's all a possibility. That's all part of the process of what we call prosecuting an application. So it's certainly, like I said, it's more common than not that we're going to expect some sort of objection from the examiner, but that's typically not the end of the world. It gives us an opportunity to then argue against his assessment. But ultimately, if we are successful, we get the registration or the grant at the end of the day, and that's, as I say, that's when you can then actually enforce or potentially enforce the rights that flow from that patent. Now, when we're talking about the filing here, it's as I mentioned, it's a very detailed document, and in terms of how we go about that process, really involves you sitting down with the patent agent or lawyer to explain what your invention is, how it works, and usually together you're going to come up with a summary of that invention and how it works. Almost, I would say, in the vast majority of cases, we're working very closely with either the inventor or the technical team here, because in many cases they actually know the technology better than we do, and so they bring to it certainly a very useful perspective, and as a result it helps us craft and prepare the application in a suitable way. Once you've got that first application on file, the advantage, of course, is that now you can publicly disclose your invention. As I mentioned earlier, if you publicly disclose your invention, it starts the patent clock running. So, but once you've got an application on file, then you're free to disclose that to the public. This could be, competitors, collaborators, whoever it is. You don't have to worry anymore because you've got your patent application on file. Then you can tell the world and label your products, if there are products there, as patent pending. So, I mean, it doesn't necessarily mean that you have rights to enforce, but it means it's in effect, it's a warning to the world. I've applied for a patent on this technology, so at least take notice of that. And in terms of the filing, oops, sorry. I'll mention it very briefly later on, but there, when we prepare regular patent applications, as I say, they are pretty detailed and very involved. There is something called a US provisional application that you can use in many instances, which allows us to cut a few corners. And so as a result, it's a sort of simplified version of a full-fledged patent application. And as a result, the costs can sometimes be reduced a little bit. I mean, I don't think it's very significant, but when cost is an issue, that can come into the equation. So unfortunately, when we're dealing with patents, just like in trademarks, they are territorial. So, if you apply for a Canadian patent, that's going to protect you in Canada, but it does nothing for you in the US or in other countries. And so when you have an innovation that can be widely applied, you really have to go through the process of analyzing which countries it would be worth seeking protection for that invention. And a much, a similar way to trademarks, when you're dealing with multiple countries, if you've got something which you think you'll protect in 10 countries, 15 countries, that can be a very expensive process. But there are a number of mechanisms that we can take advantage of to either, one, simplify that process, but probably more importantly, defer some of the costs that flow from that. If you imagine a situation where, let's say you have, let's say 5 or 10 commercial markets that you think, you would want to move into, if you wanted to protect that as a patent, you would have to file 5 or 10 separate patent applications. And as I say, that can be a very complex exercise and also very expensive. So what can we do? The first thing is we can take advantage of something called convention priority. So if you file once you file the first application, that essentially is going to buy you 12 months of time before you have to decide where else to file a corresponding application. So in a situation where, let's say, you filed in Canada today, if you wanted to also seek corresponding protection in the US, you could wait a whole year, and then 1 year later, you file a US application claiming priority from that Canadian application. And in effect, what you'd have is effectively backdate your US application as though it was filed as of the Canadian date. It's somewhat similar to the trademark situation, except it's 12 months rather than 6 months. And so, of course, this offers some advantage to a patent applicant. The main, of course, is it defers costs. And in the situation where you've used a provisional application, again, you start off with a slightly lower cost application, and so that can be significant. Oops. Very quickly, I'll touch, as I mentioned, with the US provisional applications, they can be used in some instances. I don't recommend them for all situations, but in the situation, for example, if you've got a product that's still in development and you think you might do something else with it, or you might build upon it, the provisional application is actually very useful, because you can file one provisional application, which is sort of like a skeleton application, if you like. And as you flesh out the rest or improvements to that technology, you can follow that on with another relatively low-cost application. So there are situations where the US provisional is going to be significant, but even where it's not significant, it can lead to modest cost savings up front. And then finally, in the situation where you're thinking of fairly broad protection, maybe it's a number of countries, there is something called a PCT application, where if you file the one application, you effectively reserve a right to convert that international application into a national application in any country of your choosing. So by filing that one international application, you're then later on entitled to convert that into a Japanese patent application, or a European patent application, or a Canadian application. And so again, this simplifies the patent filing process. It's, as a rule of thumb, it becomes effectively will pay for itself if you're looking at potentially 3 countries generally. So if you are thinking of more than 3 countries for your invention, the PCT typically is the recommended route. The disadvantage is that the PCT application doesn't actually ever become a patent itself. You still have to take that nationalization step later on in converting it to a national application. But it is very useful, and one of the main reasons is that by filing that PCT application, you are deferring the decision to enter those countries by up to 2.5 years. So rather than having to decide today, you don't incur the costs of those national applications until up to 2.5 years later. So I can show you through here. In the case where we have let's say we actually had a first filing in the US, we follow that on 12 months later with an international or PCT application, then we are in effect buying ourselves up to 30 months from the filing date, the decision to actually enter those different countries, Canada, Europe, Japan, wherever else. And so we don't incur those costs until up to 30 months later. And so where you have a fairly significant and valuable invention, this is going to sort of buy you time, and it's also going to sort of buy you, at least it's going to defer a lot of the costs that would flow from filing internationally. So any patent questions, Michaela? That's it for patents.
Yes, there's lots. Okay. All right. Let me start off. Okay. I have a physical product and I've applied for a provisional patent on my own without a lawyer. In order to properly discuss what I am building with judges for the competition and potential investors, I have to reveal details of the product in my pitch that are part of my provisional patent application. In order to properly validate the market and product, I also need to reveal details of the potential customers and what I'm building. Do you have any tips for this type of situation?
I would say, generally speaking, because there's a provisional application on file already, all right? In a perfect situation, if you've got the provisional application on file, then you're really free to disclose that to the public, all right? So you don't come across that problem where the patent clock is already run because you're going to publicly disclose your invention to someone. But now it starts the patent clock running, you have to file within 1 year. That you avoid that situation first of all. But you do have to be a little careful here because in the situation where you've kind of come up with the provisional application or filed the provisional application yourself, there may be risks because what if the provisional application doesn't fully capture what you want to protect? Because with the provisional application, that really is going to buy you only 12 months of time. Within that 12 months, you're going to have to file a follow-on application, a regular or non-provisional application. And so, assuming the provisional application was well done, you're perfectly entitled to then file the non-provisional application 1 year later, and you're fine. There's no issue there. The risk is where that provisional application perhaps has holes in it, or where it's not it doesn't fully disclose the invention that you would need to normally. What that means is that priority claim from the non-provisional application to the provisional application may actually fail. So there is a potential risk, and if it fails, then what it basically means is that you won't have the benefit of that priority date that you're relying on. And so I would say generally it would be fine. Like I said, if there's no issue with the extent of disclosure, you're probably going to be fine. But if there are holes in the application, then it's still a risk. And I would also add to that, when you say you have to disclose your invention, for patent rules, it has to be what we call an enabling disclosure. So you can talk about the concept of your invention, but maybe you're not providing all the information there is that absolutely needs to be shared to effectively put that invention into practice. So I can talk about the concept of my invention without really teaching you how to do it. So yeah, you may understand what I achieve, and you may understand the benefits of it, but maybe the information I share with you doesn't actually give you enough to then turn around and immediately put it into practice. So I guess it depends on the extent of the disclosure, but it has to be an enabling disclosure. So if you are just sharing concepts or giving someone the idea of your invention, that might be okay. It depends on the degree.
All right, it is 5 o'clock now, and I know we said we were going to be done at 5. Do you have a few more slides you want to get through, Ling?
Oh no, actually, I'm done for patents. What I've included what I've included in the part 2 of the presentation actually is a number of takeaways. But for current purposes, I don't think it's necessary to really go through them in detail. It's just something I guess attendees can take away and kind of use a checklist if you like.
Okay, are you good to stay on and answer like questions for another 5 minutes? Okay, I just want to say goodbye to everyone who has to leave right now at 5. Thank you for joining us, and we're so grateful, Roger and Lang, that you have given us this awesome presentation today. I've just sent out an email to everyone with links to our upcoming webinars, and if you could take our quick survey about today's webinar. I said it's 1 minute, but it's actually like 20 seconds. I would really appreciate that. But thanks for everyone who's joining us. If you want to stay on and listen to a few more questions that Ling and Roger might answer, that's great. But if not, hope to see you at our next webinars.
Yeah, thanks all. Be safe.
All right, yeah, we have a few more questions, Ling. Okay, so first question, can you explain how important figures are in an application?
Sorry, the years?
The figures are in the patent application.
Sorry, in a patent application, I would say they're typically included, but really only because in most cases at least, a picture is worth 1,000 words. So, if you include figures, they very often will help illustrate the solution that you've come up with, and just makes the description a lot easier. So it's not that they are absolutely required, but it typically will help illustrate the solution and also how to put it into practice. So helpful and typically seen, but you may have an invention where it's not necessary.
Okay, next question. If you have an NDA statement before your public presentation, would that protect your invention if you haven't already filed a patent?
Generally, I would say no, probably not. I mean, I think I'm assuming that this is in a sort of like a public context where you can't really sort of bind the public to that non-disclosure agreement, right? So no, I would say generally no. It's more the situation where you're sharing it with a third party, maybe typically one third party, and you ask them to sign an agreement to say that this is not going to be disclosed outside of present purposes. That's where that non-disclosure agreement is usually applied. So I don't think a public some sort of public declaration of some non-disclosure is going to be enough, I'm afraid.
All right. Does Fasken have any startup legal packages?
Hi, it's Roger here. Yeah, we certainly have some startup packages. We appreciate that a lot of the very promising technology companies don't have a lot of cash up front. And so we have a package of precedents that companies can use with all sorts of things in it, like an employment agreement and a contract services agreement that includes the magic language that we talked about earlier. And then we also have some fee arrangements that we can discuss and agree upon, like deferring some fees and to a particular point in time, like financing and all that. But that's certainly something that we can talk about.
Awesome, thanks, Roger. Okay, another question. What IP can protect an abstract idea?
Well, the magic word idea means that it's in Ling's bailiwick, so I'll leave it to Ling.
I think it would really, I think when you say abstract, it depends on what you mean by that. As a general rule, if it truly is abstract in sort of the patent or the legal context, then you probably are out of luck, because there is an express prohibition against patenting something which is abstract. What they typically mean in that context is where you have, for example, in the computer area, very often you're dealing with digital information, And so the starting point very often is that, well, if you've got an application or a program where effectively all you're doing is changing the ones and zeros that represent information, you know, that probably is considered abstract. Now, does that mean we can't get patent protection for it? Not always, because you know that's the presumption that it's abstract. But it may be that that information has some sort of physical manifestation or some real world implication. And so, you know, if you're dealing with, I think the traditional example is, you know, if you're dealing with a program that perhaps assesses financial information or portfolios, there you're really not, you don't have anything physical going on. And as a result, that, you know, that's objected to as patentable subject matter as being abstract. So, you know, it may be difficult to kind of really answer that question, you know, without knowing what the attendees asking about. But you know, if you want to discuss it in more detail, I'm happy to you know, to have them reach out and say, you know, here's my actual situation. You know, is there anything I can do to protect the IP on it?
Awesome. And everyone that's asked a question, if you have more questions, Ling and Roger have included their emails in the PowerPoint deck for you to follow up with them if you're interested in chatting with them. But one last question, how does a company go ahead and get a lawyer on their board? Do they become part of the team or the board?
That happens sometimes, not a lot. I currently sit on 2 medical device company boards. It usually flows out a relationship that the person has with the lawyer. And so it can be very beneficial because, yeah, the lawyer is absolutely part of the team in that particular instance. But there is some reluctance on the part of some lawyers. First of all, you don't want to get onto too many boards because you got to take the diligence that's required of the directorship seriously, and that means you have to, you know, put some time into thinking about the issues that come up in those meetings and reviewing all the meeting materials. Another option would be to have lawyers as an advisor. I mean, apart from a legal advisor. And one thing that that we found helpful with some clients is that we have had an associate sometimes for cost reasons, or maybe even, you know, a partner, serve as a corporate secretary. So the corporate secretary is, you know, attends the meetings of the board, records some minutes, just the legal parts, and then the benefit is you do have the lawyer there who can chime in on issues, but you don't have the same kind of duties and potential liabilities that are that could potentially be incurred by a lawyer, because that's one thing to bear in mind. Directors can be liable for unpaid wages and a number of other things, and so some law firms prohibit board membership. I mean, fortunately ours doesn't, but yeah, you know, generally speaking, I think it's a really good idea. Find the right person, develop the relationship, and go from there.
Awesome. Well, thank you both so much again for your awesome presentation today. And again, everyone, you can find Roger and Ling's presentation slides in the handout section or on our website in the link I just send you out. But bye for now, everyone. Stay healthy, and hopefully you get to enjoy some sun today. Thanks, everyone.
Thank you.
Thanks, everyone.